For the last 10 years, if a teenager couldn't put down their phone, society treated it as a household problem. Parents set screen time limits, confiscated devices, and fought isolating battles in their own living rooms. But those private struggles have converged. Today, these parents are at the center of a coordinated legal assault against the companies that built these apps. The centerpiece of this attack is a single legal filing. U.S. courts canned 422-MD-03047-100, or the Social Media Adolescent Addiction and Personal Injury Products Liability Litigation. The court has classified this as MDL 3047. MDL stands for Multi-District Litigation. It is a legal mechanism that takes thousands of similar, isolated lawsuits from across the country and groups them together into one centralized pressure cooker. This visualization shows the volume of the docket. It is packed with thousands of individual plaintiffs, reading like an endless ledger of families who have brought their claims to the court. And all of those claims are aimed directly at 4 specific targets: Alphabet, Meta, ByteDance, and Snap. By bundling their claims through the MDL process, these families have built a legal siege machine designed to overwhelm companies that normally rely on deep-pocketed legal teams to brush off isolated lawsuits. To understand how this works, we have to look at the people actually filing the lawsuits. When reading the court documents, you'll see hundreds of minor plaintiffs protected by anonymity. They are listed only as strings of initials: AB, JD, CW. The legal weapon these families are using is a specific classification called Personal Injury Products Liability. For years, social media companies have argued they are simply neutral platforms hosting content. The plaintiffs in this MDL claim the algorithms themselves are defective, intentionally addictive products. Under a product liability claim, the legal argument is that a line of code directly causes a tangible personal injury to a child, the same way a toxic chemical or a physically dangerous toy would. By labeling these recommendation algorithms as defective commercial goods, parents bypass the debate over free speech or content moderation. They found a backdoor to put the tech industry on trial for the psychological damage of the product itself. As this legal theory gained traction, the lawsuit expanded beyond individual families to institutional entities. This map shows the variety of public school districts that have joined the docket. The plaintiffs now span from tiny rural school boards to major metropolitan districts. One heavyweight joining the docket is the Board of Education of the City of Chicago. They are joined by other influential entities, like the Miami-Dade County Public Schools. These schools argue they are paying the literal financial price for the adolescent mental health crisis. They have to hire the counselors, handle the behavioral issues, and manage the fallout. Now they try to shift that financial burden back to the platforms that built the algorithms. The pressure on the docket didn't stop with the schools. The final escalation came when entire state governments and commonwealths entered the fight. The coalition of states suing these platforms crosses ideological lines. You have attorneys general from California and New York aligning directly with Florida and Pennsylvania. When dozens of state governments pool resources, they create a financial and political force that is difficult for even the largest tech companies to outspend. The targets trapped under this coordinated pressure include Snap Inc., the parent company of Snapchat, and Meta, the parent company of Facebook and Instagram, which has borne the brunt of the legal assault. The weight of this coalition recently forced a significant crack in the tech industry's armor, a $17 billion settlement between states and Meta regarding child safety. That multi-billion-dollar payout falls directly on Meta's leadership. This settlement shows that the product liability strategy is capable of extracting significant financial concessions. By treating algorithms as consumer goods, the coalition found a way to bypass the liability shields these platforms have leaned on for a decade. We saw the exact same structural legal strategy happen in the 1990s. When individual lawsuits against Big Tobacco failed, state attorneys general coordinated their efforts, grouped their claims, and finally broke the industry's corporate immunity. Meta's settlement provides a template showing how a tiered alliance, from individual families to state attorneys general, can successfully force these platforms to internalize the societal costs of their design choices.